Afternoon, everyone. We're going to start our first afternoon panel, and before we get started, on behalf of the committee, I want to thank all of you for being here. You guys have, we've been hearing from a lot of stakeholders. You guys have, no stake in this outcome, but there's information that we hope we can hear from you to help us sort of understand some issues that have arisen for us. And so we want to let you know, particularly because you have no stake in the outcome, how much we appreciate all of you being here today. This is what we call our views from the military. Before we get started, I want to remind everybody, if you have cell phones, make sure that they're off so they don't go off in the middle. We have with us Brigadier General John Baker, Lieutenant Colonel Todd Phaneuf, Colonel Stephen Newman, and Captain Eric Price. And so we'll start with Brigadier General John Baker. And what I would ask all of you, since your world is so very different from our world in a lot of ways, if you give us, I know you've all given us written submissions, but if you could each give us a little bit of an overview of what you do and how you do it and why you do it, and then we'll be asking you some questions. So, and let me correct myself, it's Brigadier General John Baker, it's Lieutenant Colonel Todd Phaneuf from the U.S. Air Force, Colonel Stephen Newman from the U.S. Marines, and Captain Eric Price from the U.S. Navy. So, all right, Brigadier General.
Good afternoon, ma'am, and fellow panel members. Thanks for inviting us. You say that we have no stake in this outcome, but we do.
Can I ask you to get real close to the mic? Thanks.
We look to, when we talk amongst ourselves, we look to the federal model as the model that we want to get to. Steve and I have known each other for a long time, and we've often talked about how we can improve the military justice system, and we continually look to the federal system as the one, in our view, is kind of the model that we want to get to. So it's interesting that the model that we want to get to is under review. So I'm the Chief Defense Counsel for the Military Commissions. And I'm also the officer in charge of the Military Commissions Defense Organization. What that basically means is that I supervise the defense counsel that provide defense services to the detainees down at Guantanamo. We have a kind of a hybrid system, and Steve, Colonel Newman has provided a really good overview of the military justice system. And our model is a little different. It's a little different. It's not the complete court-martial model, nor is it the federal model. They seem to have taken some parts of both and kind of kludged them into a new system. I understand that you're looking at structure and resources. Structure and resources is something that all of us look at all the time. I know that from my vantage point at the military commissions, that we feel like our defense teams have been dramatically under-resourced. I'm new at this job. I got here last summer. I spent about 6 months studying my organization, studying the resources that we had, studying the counsel that I had assigned, studying the magnitude of the cases that they had to defend, and I came to the conclusion, similar to my predecessors, that we're dramatically under-resourced. The way that we get resources is that we have to go to the convening authority. And the convening authority is a kind of a quasi-judicial official who is in charge of making monetary decisions on resourcing. In the commission system, I assign counsel to cases, but then I have to get the counsel resources to do their job. I have no budget. I can request an increase, as an example, I've requested an increase. Each of my capital cases has one learned counsel. I've requested that they have a second learned counsel. I've requested a substantial increase in the number of paralegals that I provide, the number of attorneys that I have that defend the cases. But I make a request to the convening authority. The convening authority makes a decision on our resourcing requests, and then the individual trial teams, if the convening authority were to say no to something, the individual trial teams could then take that denial and go to the judge for relief. But again, we really look to your model as one that we want to emulate. There's a couple things I guess I'd like to highlight that are a little bit different than what Steve talked about, just to give you a couple of differences from our system from yours. One is that we don't provide indigent defense services. In either the court-martial system or in the commission system, every accused gets a attorney that's assigned by either the individual services or, in my case, to the Military Commissions Defense Organization. If that individual hires a civilian attorney, either through their own means or through some sort of pro bono arrangement, the counsel from our organization stays on the case with some limited exceptions. Another big difference between our system and the federal system is that we have no, I think I'm going to use the right term, we have no imputed disqualification. By that I mean, if we have a case with a series, if we have a case of a conspiracy with a series of co-conspirators, a single office can represent the same individuals. Our rules of professional responsibility have been written to allow that. The supervisory attorneys control the detailing of counsel. So, as an example, in our capital cases, we have learned counsel. The capital teams identify somebody that they want to hire. I ensure that they're qualified, and then we go ask the convening authority to fund them. But which lawyers go on what cases is our decision, and it doesn't get to the judge to decide which lawyers do what cases. And again, we have this kind of weird's not the right word, but a different arrangement where we have somebody that is kind of a quasi-judicial official, the convening authority, that makes our resourcing decisions. Where we see a problem with the role of the convening authority is that the convening authority is the same person that makes a decision whether the charges are referred to a court-martial. So while they're a quasi-judicial official, they're also a quasi-prosecution official. And I see that as a large flaw in our system. That's kind of the extent of my prepared remarks. I'll answer any and all questions that you have.
Thank you. Lieutenant Colonel Todd.
Thank you. Members of the committee, thank you for this opportunity to speak to you today about our structure in the United States Air Force. As a defense counsel, I'm grateful for this opportunity to discuss this important topic. I am the Chief Senior Defense Counsel for the Eastern and European regions. So essentially, I supervise 7 senior defense counsels who are all the rank of major, and then they in turn supervise 28 area defense counsels who are the local counsels at each installation within our regions. And we have 25 defense paralegals spread across those installations. We form about a third of the 186-member Air Force defense team worldwide. They're all professional officers and non-commissioned officers who are dedicated to providing defense services in a zealous, ethical, and professional manner. My team provides services for about 100,000 airmen across our region. This is my 3rd assignment as an Air Force Defense Counsel. I served as an area defense counsel at Ramstein Air Base in Germany for 2 years, and then I was a senior defense counsel at Langley Air Force Base in Virginia for 3 years. Sort of the organization of our service, basically coming out of the Vietnam era, we decided to reorganize our service and our defense services, because at that time, prior to that, we were basically assigning a counsel per case. So the staff judge advocate at an installation supervised all the attorneys on that installation and would assign one person defense role and another person the prosecution role. But they were supervising both the defense and the prosecution, and they would change depending on the case. So back in 1974, we decided to take the defense counsel completely out of the chain of command, basically for the at least perception of unlawful command influence on our defense counsel. So mostly because we wear the same uniform, we appear the same as the prosecutors when we're in court. So we wanted our clients to understand that we were going to zealously represent them, and there would be no influence from the command structure that they were responsible to. Okay, our defense services are headed by the Chief of Trial Defense Division, who's my boss, Colonel Dan Higgins. He's an 06 or colonel. We have 186 active duty officers and non-commissioned officers divided in 5 circuits across the world. Each of these 5 circuits are headed by a lieutenant colonel like myself, who runs the defense services for those sections. Okay, our senior defense counsel are typically someone who has served at least 2 base level assignments and at least spent a year, typically 18 months to 24 months as an area defense counsel. The 21 SDCs across the world are tasked with providing not only the day-to-day supervision of the Area Defense Council, but they also are responsible for defending airmen in the most serious cases at trial.
Did you say S? What was the acronym? ST?
Senior Defense Counsel,
Senior
SDC. Okay, like I said, our ADCs are our base level, installation level defense attorneys, and they are responsible for their base, but they also, depending on conflicts or whatnot, may do cases at other installations as well within their regions. Typically, in order to get an assignment as an area defense counsel, a counsel would have to do at least 10 court-martials before they move over. Our trial defense division falls under the Air Force Judiciary Directorate, acronym of JAJ, and this is also headed by a colonel. The Air Force Judiciary Directorate contains 5 divisions: the Trial Defense Division, the Appellate Defense Division, the Government Trial and Appellate Counsel Division, our Military Justice Division, and our Clemency, Corrections, and Officer Review Division. So this includes all the trial and appellate counsel, both defense and prosecutors, and the Policy Division. The Director of the Air Force Judiciary is responsible for our administrative control of all 5 divisions. While they exercise administrative control, the Judicial Directorate is neutral and does not dictate how Trial Defense Division's attorneys represent their clients. And then that Air Force Judiciary Directorate falls under what we call Air Force Legal Operations Agency, or AFLOA. It is currently headed by a 2-star or Major General, who is the only commander within the United States Air Force JAG Corps. Again, AFLOA does have administrative control over the Trial Defense Division, but does not dictate how any of the attorneys in the Trial Defense Division represents our clients. Similar to General Baker's remarks, we also have a convening authority that dictates expert expenditures and whatnot on cases. How we go about it is the counsel in the case applies to the convening authority for an expert on a particular case and provides justification for their need for the expert. And then if the convening authority denies that expert, then we go to the military judge and file a motion in order to get the expert approved if the military judge sees that as appropriate. Again, I'm grateful to be here today and answer any questions that you have. I'm proud of the Air Force's independent defense function. I'm proud to serve as an Air Force Defense Counsel, and I appreciate this opportunity to be here today and discuss the structure of Air Force Trial Defense Division with you.
Thank
Thank
you.
you.
Colonel Newman.
Good afternoon, ladies and gentlemen. I am Colonel Stephen C. Newman, and I'm honored to have the opportunity to be here, and I'm grateful for your invitation. Thank you for your interest in what we do in the Marine Corps for the defendants in the Marine Corps, and thank you for what you're doing as a panel. I hope to be able to answer your questions that you may have regarding our structure, how we function in the unique system that we call the UCMJ. I previously provided the committee with some extensive written comments. There are a few key points I hope weren't lost in the length of that submission. Specifically, I hope to take about 5 minutes to highlight what I think are 4 critical points. First, why does the Marine Corps have a Defense Services Organization, or what we call the DSO? Most obvious answer is because the Marine Corps has a statutory obligation to provide military justice services, and that includes both the criminal defense and prosecution element. But more importantly, why nest those services, the defense services, within the structure of the DSO? It is to ensure Marines and sailors in our system receive independent, conflict-free, and vigorous defense services from an attorney sheltered from the influence of command. Over time, we learned that the traditional USMC structure simply did not work well when applied to the adversarial process. Having a unified command structure for both trial and defense services led to natural and foreseeable conflict issues, which I hope I highlighted for you in my written submission. Second, Why is the DSO structured the way it is? As you can see from my submission of Chapter 2 of the Legal Administration Manual and the policy memos, many of which were authored by General Baker, the DSO is generally aligned with the rest of the Marine Corps in a model which focuses on centralized command and control, but decentralized execution. In that regard, my most important responsibility and my most powerful tool is that of case assignment, or what we call detailing. I am responsible for making sure we get the right attorney on the right case. But while that authority is consolidated in me, I exercise that authority in a decentralized fashion through my 4 Regional Defense Counsel, or RDCs, who themselves execute it regionally through their Senior Defense Counsel, or SDCs. So in fact, our most powerful tool, detailing, is exercised at the lowest possible level of leadership, the Senior Defense Counsel. Just as importantly, each region is structured the same, has the same processes in place, and generally looks like the other. This is so that a Marine can move from one coast to another and fall in on the exact same processes as he or she had in the past. Furthermore, and importantly, it ensures that everyone knows what the expectations are, because they are the same across the globe. Third, what are our organizational strengths? I've already highlighted what I consider to be our greatest strength, that of detailing authority. But another equally important tool is a mutually supportive culture, not just within the individual branch offices, but organizationally. This is important because we are tasked with taking on an institution which yet retains the power of personnel assignment, resource development, resource allocation, in other words, power of the purse. We and the DSO support each other in the traditional sense, through murder boards, case consultation, sharing best practices, etc., but also through non-traditional means. One of those means is technology, specifically SharePoint, a Microsoft Outlook web-based information and networking software program that is a wonderful way for the DSO to share information in near real time. From the perspective of the line attorney, SharePoint is a case management and consultation tool. But from the perspective of me as CDC, it serves as an organizational supervision tool for me to exercise command and control over a group of 70 attorneys spread across the United States and Asia. This, at least partially, is how I execute policies and procedures, which I hope help foster a supportive environment from the top down, as well as from the bottom up. Finally, the supportive environment we've developed in the DSO is well known across our community. Everything from the way we train to the way we support one another in the courtroom makes the DSO a place where Marines want to work. Work in the DSO has become desirable and is career enhancing. But no discussion will be complete without mentioning our weaknesses, and there are a number of them. In the interest of time, I'll simply say that our greatest weakness is this. We remain resourced in conjunction with the prosecution element, and while functionally independent, remain obligated to the command structure for support and evidence development. We compete for training dollars, personnel assignment, and other resources with the prosecution. This may seem no different than in any other system, except that here the persons holding those resources are the same who are responsible to those who bring the charges, the commanders of the convening authority. As a result, there yet remains an unnatural imbalance in resource allocation and evidence development. We have 2 highly qualified litigation experts. The government has 4. They have complex litigation teams with integrated criminal investigators. We have none. The regional law center directors manage the budgets for my regional defense counsel and decide who's assigned to the DSO. My RDCs have no budget they can call their own. So while we are functionally independent for a supervisory purpose, we remain constrained by our reliance on the government, who retains the power of the purse. In sum, the DSO does not enjoy complete independence. However, the value in Marines defending Marines far outweighs any other feasible alternative. That does not mean that my organization is satisfied. Quite the opposite. We've been attempting to engage in strategic change to address our weaknesses. From the counsel on the ground building the record to my policies and strategic messaging, we are constantly highlighting how our structure can be improved while preserving our unique culture. As I said in my written submission, strategic change requires tactful patience. It's hard, and it requires commitment. The best approach in generating momentum for strategic change applies to me as well as to my counsel. Build the record. Once again, thank you for the opportunity to be here, and I stand ready to field any questions you may have.
Thank you. And Captain Price.
Yes. Good afternoon. And on behalf of the Judge Advocate General of the Navy, Vice Admiral James W. Crawford III, and the men and women of the Navy JAG Corps, thank you for the opportunity to testify here today. I am Captain Eric Price, JAG Corps United States Navy, and I currently serve as the commanding officer of Defense Service Office North, which is in Washington, D.C. It's one of our 4 Defense Service offices. We've essentially divided the world into 4 regions. My area of responsibility essentially it covers 19 U.S. states, from Great Lakes, Illinois, to the Washington, D.C. area and up the East Coast, and what we call Europe, Africa, and Southwest Asia, with offices in Spain, Italy, and Bahrain. So 7 total offices. Just very briefly on my own background, this is my 3rd tour as well as a defense counsel. As you may or may not be familiar, judge advocates, we vary in career paths. Very rarely does one stay a litigator for an entire career. I've been a trial defense counsel, a prosecutor, an appellate defense counsel, a commanding officer of one of the trial and prosecution offices, and then a trial and an appellate judge in the Navy, and deputy chief trial judge of the Navy Marine Corps, as well as on the Court of Military Commission, excuse me, the United States Court of Military Commission Review is both a judge and a chief judge. As I mentioned before, we are assigned primary responsibility for defense of and other representational legal services in defined geographic area of responsibility. We represent sailors, Coast Guards, and on occasion Marines before courts-martial, administrative separation boards, and boards of inquiry. In addition, we provide advice on defense-related matters such as non-judicial punishment, criminal investigations, inspector general investigations, and other adverse administrative actions. In the Navy, both prosecution and defense services are provided by individual commands headed up by a commanding officer like myself, and each are assigned primary responsibility over a geographical area of responsibility, as I've defined mine previously. By way of example, in my area of responsibility, there are 4 separate region legal service offices, the commands that are tasked with essentially providing support to the commanders. They provide both internal command support and prosecution services for the commanders. As background, the Judge Advocate General of the Navy supervises legal advice and related services throughout the Department of the Navy, except for the advice and services provided by the Department of Navy General Counsel. He also leads 2,300 attorneys, enlisted legal men, and civilian employees of the worldwide JAG Corps. I say this because his deputy plays a very unique role that I'm about to define, and this sets us a little apart. Each of the services structure ourselves a little bit differently. The Deputy Judge Advocate General, who assists the JAG in performance of his duties, also has additional duty as what we call Commander Naval Legal Service Command. The Naval Legal Service Command was established in the 1970s to provide and oversee legal services worldwide, including both prosecution and defense services. Commander Naval Legal Service Command has performed these duties since. Stated another way, Commander Naval Legal Service Command remains the reporting senior for all of our Defense Service Office commanding officers, as well as the commands that head up our prosecution offices. So we apex from a shore infrastructure perspective at the Commander Naval Legal Service Command. He's a 2-star admiral currently, Rear Admiral John Hannock.
Can I ask you to pull the microphone a little
Oh,
bit
yes, ma'am,
closer?
I'm sorry.
That's okay.
And additionally, since 2013, Commander Naval Legal Service Command has also overseen the Victims Legal Counsel program. So he actually oversees essentially the provision of the vast majority of legal support services provided to the Navy. The commands that comprise Naval Legal Service Command include 4 defense service offices, of which mine is one, 9 region legal service offices, and the Naval Justice School. The Naval Justice School is responsible for training, legal training, development of doctrine and training, and I won't discuss that anymore, but they provide those services for accessions in the Navy, Marine Corps, and Coast Guard, as well as our enlisted legal professionals, and they also provide training for line commanders, particularly in the Navy, and non-legal types who perform legal functions as a part of their duties. The commands that comprise NILSIC, as I mentioned, there are essentially 13 of our functional commands, and the commander is assisted in the performance of this function by 3 chiefs of staff. And again, this is institutionally where we're a little different. We have a chief of staff region legal service office, which I mentioned earlier, oversees the Navy's 9 REALSOs. They also supervise all trial counsel assistant programs. We have what we call a TCAP program, which is consistent with the other services, and they oversee the provision of command advice throughout the United States Navy on the shore side of the infrastructure. Again, the REALSOs are dedicated to providing legal services and solutions in support of military justice and other legal issues involving Navy and, upon request, Marine commands located within their area of operation. As you can understand, the highest priority is given to fleet and operational units, particularly those deployed or preparing to deploy. The second chief of staff, and as I sit here, I realize I should have produced a visual image. It would be much easier to understand. But the second chief of staff is Chief of Staff Defense Service Officer, or CAUS DSO, as we say. The CAUS DSO oversees the 4 DSOs and supervises our Defense Council Assistance Program, which is, again, our resource center for everything from research, will on occasion try cases, and provide administrative and reach-back support for our counsel in the field. And again, the CAUS DSO's area of responsibility includes the entire United States Navy and Coast Guard, anyone who's appearing before courts-martial or any other administrative proceeding is entitled to either representation or advice services under the cognizance, again, of CAUS DSO, where the individual commands provide the actual service. In addition, the third Chief of Staff, again recently created in 2003, is the Chief of Staff Navy Victims Legal Counsel. We call it the VLC program. This is a unique in the Department of Defense. Not that we're unique, but the Department of Defense has a very unique victim legal counsel program that many would say is perhaps on the cutting edge of victim services, particularly currently focused on sexual assaults, but victim services anywhere in the country. And we have, of course, stories we could tell you about each of our services, but I'll just plant that seed. It's a little different. With respect to a brief history, you've heard us all talk about a time when we brought our lawyers into the chain of command of other lawyers. That essentially was directed by the Secretary of Defense in 1973. So all the services essentially after 1973, 74 and a little bit later, lined up our defense services so they all are supervised by attorneys. Prior to that, they were not. Since that time, they've been supervised by attorneys. You've heard sort of a thumbnail sketch here of the varying models we use in the 3 of the services that you've heard spoken about here today. I would only note that in 1976, we created the first model, and at that time, very Navy-like, we put all of our services in one command, much like a ship at sea. They were called Naval Legal Service Offices, and at that time, trial counsel, which would be prosecutors, defense counsel, legal assistance attorneys, claims attorneys, and those providing assistance to commands that did not themselves have attorneys, all worked under the same command structure with the same reporting senior, and often would not often, but would routinely move between those different positions. So a very unique model in that regard. In 1988, the Coast Guard and the Navy entered into a memorandum of understanding with the Navy, and the Coast Guard provides attorneys to assist in certain Navy offices. In exchange, the Navy provides most Coast Guard defense advocacy services nationwide. Currently, we have 7 Coast Guard attorneys serving around the Navy's legal offices and defense positions. And again, we provide the bulk of the Coast Guard's trial defense needs, or counsel for the bulk of the trial defense mission. In 2006, we realigned slightly, and we essentially brought our shore-based, in the Navy legal community, all of our shore-based infrastructure under the Navy JAG's cognizance. And at that time, we then broke out what were called trial service offices, which were primarily, this is when we separated the trial or prosecution function from the defense function, from being in the same command, but they're separated, still reporting one step up the chain of command to the same commander, but each have separate and distinct commanding officers. So again, we're a little unique in that regard. In 2007, for a variety of reasons, not the least of which is we recognized that our caseloads were diminishing to some degree, particularly in the lower level cases, which we had historically used as training grounds. We in the Navy created a thing we called the Military Justice Litigation Career Track as an effort to identify career litigators. So unlike when I came in on active duty, as mentioned earlier, it was difficult to stay a career litigator. Now we have that as a career path. It's a defined career path. Obviously, it's intended to improve and retain our military justice knowledge and advocacy skills. The goal is to combine both courtroom experience, training, and education with oversight by access to senior seasoned litigation mentors to help our judge advocates develop skills needed to become preeminent trial attorneys. By September of 2012, we had 8 Naval Legal Service offices, which still provided the defense function and legal assistance function, and 9 trial service offices. In 2012 was our last iteration, and in that iteration, we disestablished the Naval Legal Service offices, and we created a standalone defense service office institution much similar to the other services, but yet different. That's, again, the system or the command that I have now as a Defense Service Office. We moved the legal assistance mission to the Region Legal Service Offices, so now our Defense Service Office is focused solely on criminal defense and adverse administrative proceedings. Again, this structure was designed to improve the military practice by aligning the right number of litigation specialists and experts with the Navy's court-martial caseload, particularly in view of increased complexity. I would note just a few comments. I probably have a few minor disagreements with some of the comments I've heard from some of my colleagues. One thing I think the Navy does very well is we allocate our resources, particularly the military justice litigation career track resources, are allocated relatively evenly among prosecution and the defense, spread among these varying commands. And I won't say that it's perfect at all times. On occasion, it'll be a little out of balance, but that balance could go either way. So in that regard, by identifying this one core of litigators who are our primary trial defense counsel, we manage them through a career, and they move back and forth between defense and trial billets, not by days or weeks, but in the course of what we would call tour of duty, usually 3 years, can be a little bit less. They will also go on to be, presumably, if they've established the appropriate credibility and expertise, our future military judges. And we're experiencing that our current generation of military judges. The majority are members of this career track and have, I think, demonstrated the dividends that can be paid by having focus like this. One other area where we're a little different than the other services, and this is where we're different than the Federal Public Defender model. We do not independently have access to investigators generally or to expert resources. Now we do obtain that, and by law we're supposed to have equal access under the Uniform Code to the government, and we generally gain substantial access. I think it's debatable whether it's always equal. I think that's probably a fair debate, but as a matter of law, we have access to government experts, and with proper motions, we can obtain experts from the outside. A unique aspect of our system, as mentioned earlier, is it's a command-centric system. Prior to trial, you actually have to ask the commander to fund or make someone available. Once the trial starts, the trial judge actually has the authority to do that and make experts available. But experts routinely appear in our courts. They just are not part of the defense bar. Sometimes they'll be from other Department of Defense medical centers, particularly a lot of experts, DNA and otherwise, or they'll be outside experts. In addition, where we're a little bit unique in the Navy, we have a pilot program we've just started called the Defense Legal Service Specialist Program. And it's essentially, and I need to be careful because the Judge Advocate General may be listening, but among their many functions, one of their functions will be to perform defense investigations. So in that regard, we're trying something a little bit new in the Navy, and I believe we're the only service doing that currently. We've hired a number of folks, 8 currently, to work at the GS-13 level. So for those who know, which most do the government service model, you recognize that's not an entry-level pay grade. So we've hired some pretty high-quality folks, investigators, criminal investigators, defense investigators, that type of person, paralegals with substantial investigation experience. So we're working that. I guess I would add one other footnote before I close. I did have, General Baker mentioned something earlier that frankly hadn't even occurred to me. My last tour was only 18 months, but before reporting to this job, I was the senior Navy rep to what's called the Military Justice Review Group. The Military Justice Review Group did a comprehensive review of the Uniform Code, and the primary reference was, in fact, the United States Code applicable in Article 3 criminal trials. And there's currently a pending massive revision. It's a substantial revision to the Uniform Code pending currently before Congress that actually was a byproduct of that code. So that was both enlightening, and as General Baker said, we really both learned a lot from looking at the Article 3 model, from working with folks in the Department of Justice and the Administrative Office of the Courts. And I think we learned a lot of things that we could do better, and we also recognize that we do a lot of things very, very well. So I mention that for whatever that's worth, in case that may prompt a question or a thought. That being said, again, thank you for your time and the opportunity to appear here today.
All right, let's start with Mr. McBride.
So thank you, gentlemen, for being here. Very, very helpful and interesting to hear about your system. Maybe I'll start with you, Captain Price, just since you had the floor a minute ago. So just to confirm, it sounds like perhaps unlike Colonel Newman, who was describing the command of the chain of command, just so we understand, are you saying that the current model in the Navy is to have prosecution and defense reporting up to separate commanding officers, which in turn report to a superior?
That's correct. Commander Naval Legal Service Command is an Echelon 2 command, meaning one step removed from the Chief of Naval Operations. Subordinated to him are Echelon 3 commands, 4 of which are DSOs, 9 of which are Regional Legal Service offices.
And so talk a little bit about, whether, does having sort of one ultimate commander that, for whom both prosecution and defense roll up, is that perceived, is that a command position, the CNS perceived as sort of a straight shooter, fair, impartial command that doesn't, sort of lean one way toward defense or prosecution?
I can say I'm sure that you could find varying opinions if you talk to different folks. In my experience, the answer to that question would be yes. In fact, I think the creation of the Chief of Staff model who run the data, when I say run, they're responsible for day-to-day management and direct liaison, both isolate and insulate the commander from the day-to-day workings. The commanders that I've dealt with, in both as a CO of a Regional Legal Service Office and a Defense Service Office, generally stay out of your daily business. They are not interested in what's going on daily unless it's a heads up that something significant is about to occur. Of course, those are more common from the prosecution side than you could imagine from the defense side. That said, with respect to resourcing, we depend on the same structure for resourcing. In the Navy, the administrative and support to the Judge Advocate General is provided within the Office of the Judge Advocate General. And I regret not presenting an org chart, and I will submit one perhaps afterwards to help clarify this. But the Office of the Judge Advocate General does many significant things. But what I'm talking about here is primarily what we'll call the operations management function. And in that regard, they don't distinguish. When they're supporting, by way of example, a defense office or a prosecution office, there's no distinction. We have our budget battles, so to speak, in advance. Budgets are allocated. And if, say, by way of example, there's something like sequestration, as best as I understand it, I wasn't in the position at the time, there's generally a fair share approach. And we work, there may be some discretionary funding, and on individual issues, we work to actually advocate for release of those funds. But I think it's fair to say that the commander goes to great lengths to preserve absolute independence with respect to the administrative side of the system. And secondly, the commanding officers in the traditional Navy model. It's very important, I think, to understand the Navy model. A commanding officer often in our history would go far from home with limited guidance and carry out the plan of the nation, and sometimes with great success. Sometimes there may be challenges raised, but the model continues and persists to this day. So the commander puts great faith and confidence in their commanding officers to actually manage the day-to-day functions. And so with respect to advocating for resources that are case-specific, that's actually something that we do with the convening authorities, and the Commander Naval Legal Service Command has no role, or the trial judge. I would make one additional comment, just a footnote. I made reference to the DLSS. I would note that was actually a proposed change from the Response Systems Panel for sexual assaults, a joint congressional DoD panel. It was a proposed improvement in the military justice system. And as I say, my understanding is the Navy is the only one that's implemented that to date. But use those by way of example. We have funding for the individuals within the Navy, but currently we will be, if we're going to spend a lot of money for travel and investigation, we may be required to go to a commander to obtain funding for that.
But just to clarify, Captain Price, it's the same entity or the same command which is essentially setting budget for both prosecution and defense?
That's correct.
Okay.
Yes, sir.
And Colonel Newman, could you talk just a little bit more? You mentioned that one of the weaknesses in your view is that, I think maybe unlike what Captain Price described, perhaps the defense component kind of rolls up to a prosecutor or somebody who has sort of, maybe less independence than what Captain Price described. Could you unpack that a little bit for us?
Yes, sir. Well, it doesn't roll up to a prosecutor.
Okay.
We are structured into 4 basic regions, both on the government side and on the defense side. We have East, West, Pacific, and National Capital Region. In each of those regions, there's what we call a Legal Services Support Section, or an LSSS. That LSSS is typically headed by an 06 colonel. That 06 colonel is not a commander, and that 06 colonel is not necessarily a prosecutor, but that 06 colonel is, in my view as a defense counsel, a government agent, so to speak. And that individual is responsible for all functions within that organization, including the budget, personnel assignment, et cetera. So when a Marine comes out of Naval Justice School as a lieutenant and is assigned to LSSS East at Camp Lejeune, North Carolina, they fall in on that organization, and that OIC, that officer in charge, will decide if that individual is going to be in defense, in prosecution, in civil law, review, doing case review, that sort of stuff. Once that person is chopped to me into the DSO, they get a letter from that OIC that says, you are a defense counsel. And this is where we're different from the Navy. And that letter says you're going to stay a defense counsel for 18 months, minimum of 18 months. Sometimes they stay longer, but that 18-month window is their rotation date. That creates challenges for me because it takes about 12 months to get a guy or gal trained to the point where they're really effective as a defense counsel. And then if we're going to rotate them at the 18-month mark, in order to make sure they're not bringing cases with them, we have to cut them off. And so I really have them for a short, maybe 4 months, where they're a truly effective, independent operator in the courtroom. And all those are decisions that are based that are made by the officer in charge of the LSSS. My regional defense counsel also fall in on that structure. So if you ask me, I retain operational control over all defense counsel. And I define operational control as being defining their day-to-day operations, what they do on a day-to-day basis. I delegate that to the regional defense counsel, who then sub-delegated that down to the senior defense counsel. There's roughly 10 offices in the Marine Corps that have a senior defense counsel. But the administrative support comes from the LSSS. That doesn't typically create a lot of friction. Usually we're able to function pretty well. From time to time there will be flare-ups, but nothing that has really created, at least not since Lee, hasn't really created any real major muscle movements at the appellate level. Does that answer your question?
Yeah, I think so. And then just a question for General Baker and Lieutenant Colonel Fanoff. So I think, for those of us who grew up sort of in the civilian prosecution defense paradigm, your system seems, somewhat strange and unique. And so there are any number of questions that come to mind as we're trying to put ourselves as either prosecutors or defenders or, hypothetical defendants in your system and how they would react to that. So I guess a couple questions would be, if you are a defendant in the, in the Air Force or in the Marines, and you're aware of a system where, you recognize a guy or gal who spent 18 months as a prosecutor, and now you realize they're sitting on the other side of the courtroom and they're a defense attorney, or you stop to think about the fact that, this is all sort of under one roof, and that, further up the chain there may be, a commanding officer that's sort of making decisions about, how to pick amongst their children, and I'm going to give the defense this much, I'm going to give the prosecution that much, as opposed to sort of our system where we believe that the Justice Department and the Federal Defender programs are separate and distinct, and they're friendly but zealous advocates pursuing you know, their own resources and so forth. So I guess the question there is, do you ever sense amongst your clients any sort of a optics issue or fairness issue that the same person may be a prosecutor one month and a defense counsel the second month? Or to the extent your system is not sort of the way Captain Price described it, with more or less distinct chains of command, to the extent it's somewhat more muddled or messy, does that ever, you know, create fairness issues on the parts of either you or your clients?
I guess I'll go first. I'm going to answer first kind of my experience when I had Steve's job.
And can I ask you to speak in the microphone?
And then second, in my current job. So I was concerned about that substantially. I mean, it's pretty hard to walk in and talk to a young Marine and you're wearing the same uniform as the guy or gal that sent them there. And that's part of the reason why in the 2008, 9, 10 timeframe, we ended up reorganizing our defense services and really established the model that Colonel Newman talked about. It's a little bit of trust me. When I take a step back and think about in my career where I've been a defense counsel, a prosecutor, and a judge, I'm a better defense counsel because I was a prosecutor. I was a better prosecutor because I had defense experience. But now in my current job, you think it's hard having your clients to trust you when you're in the same service. In my scenario, we represent the detainees down at Guantanamo. And at virtually every step of the process, my defense counsel have broken their word to their clients. And by that, they promised them that the meeting rooms that they meet their clients in aren't bugged. Well, they have been. They promised them that the judge is the person that controls the courtroom. We've had incidents where an outside agency has interrupted the proceedings. We tell them that their attorney-client notes and their legal materials won't be touched by the government, but they have been. I am, of all the things I've done in my life, this is the job that I'm most proud of, because I lead an organization of people that are absolutely dedicated to their job. It takes a long, long time to build a trust relationship in the commission process. How do you do it? Perseverance. You demonstrate that you're gonna be there and fight for your client. But a lot of people ask me, how come the commission's process takes so long? We're where we are in the timeline because there's been repeated government intrusions into the defense function. I mean, we lost 15 months on a case. We've lost 15 months in a hearing because there is an FBI informant on one of the defense teams. That's hard to gain client trust, but we keep plugging. The way we ultimately do it is you stand up in court and you advocate as best you can for your client. I'm not sure that answered your question, but there was a soapbox I felt like I could stand up on.
Well, sir, similar to the Navy model, our counsel typically, when a JAG comes into the Air Force, they work for their first 2 years, maybe first 2 assignments in the prosecution side, and they're not doing solely prosecution work. They're also dealing with civil law, legal assistance, a myriad of other legal issues at the base legal office level. And then once you prove yourself as a litigator in the courtroom, then you get the opportunity ultimately to come over to the defense side. And we'll do a defense tour. Our typical tour is 18 to 24 months. I would say the majority is probably 24 months, but things happen sometimes where it's only 12, but in general about 24 months at that area defense counsel level where they are in a separate office. And we do our best to show our clients that we don't answer to anyone on that installation, and we don't. Because ultimately their chain of command comes through their senior defense counsel up to my position and then up to my boss's position before it kind of comes back under the Air Force Judiciary and ultimately Air Force Legal Operations Agency. So, you know, some clients didn't trust me right away, but I can tell you, much like the general said, you know, we show them by fighting for them day in, day out, and they see us advocating for them, and that's where they understood ultimately that we were there for them, and they were very appreciative of the services we provided for them.
Just one
Sure.
last question. You know, this is, I hate being asked this kind of question, you know, when I'm sitting in your side on a panel, because it's really just a hypothetical, but it's really to try and help inform us as we're thinking about, you know, in the civilian system, where to house the federal defender. And, you know, should it be left in the judiciary? Should it be pulled out entirely and sort of float in a, you know, its own org chart of its own? But the question is, you know, if you had a magic wand, you know, if this were Harry Potter world and you could wave a magic wand, would any of you take the defense function and, you know, pull it outside, you know, the Marine Corps, the Navy, at least that part of the Marine Corps or the Navy where the prosecution also resides, to try and have it just spun out completely in its own little box with a dotted line to, you know, the CNO or whomever, as opposed to sort of housed within the same basic organizational component that also includes the prosecution. So the question is, if you could spin it out and pull it away so that it's just completely, you know, separate, not even reporting up, you know, Captain Price to that, you know, independent two-star at the top, you know, would anybody do that?
My organization is set up that way.
Okay.
But the problem isn't who you report to, it's who owns the purse. Because I mean, my folks are dramatically under-resourced. I can't give them what they ask for. I have to go ask somebody to get that for them. But we have a completely separate, independent chain of command. That, and you know, on the defense side, that only goes so far. I mean, what an individual counsel is going to do or an individual defense team is going to do on an individual case is up to them. But what they really want from us, besides, you know, an independent boss, is what they really need from me is the ability to give them things. And I can't do that.
So you would spin off the funding maybe, or the budget?
And, you know, that, I'm going to give you a kind of maybe answer. And the reason why I say maybe is the one nice thing about our system is that we really never have to say no to anybody. So if there's a finite pot of money, I'm going to have to choose between two defense teams to give them X. So the defense supervisor would do that. Under our system, the two defense teams can then go to the convening authority and to the judge, and there's really no separate, there's no separate all-encompassing budget. Money is kind of put to the problem. There's no one large budget that is managed, for all of their cases.
We've talked about that, and again, I think the issue comes with exactly what the general talked about. I don't have to say no to my counsel, and if I did say no, is a judge going to ever side with them when the prosecution is going to point, well, your boss said no, so why should the judge now provide this expert or this funding for you? And so I think that's the area where we think that we cannot separate it out, and we need to have that convening authority funding to ultimately, so our advocates can fight and know that we're behind them and we're doing everything we can for them, and they don't have to think, we're favoring one over the other or situations. So, I don't see a way we can fully get out of the system.
In direct answer to your question, I would say yes. But from the Marine Corps perspective, anything we did would first and foremost have to be sensitive to those unique cultural aspects that I pointed out in my written submission. We have to preserve and protect who we are as Marine officers, first and foremost. That's our mantra. I'm not afraid of General Baker and I have had this conversation for a long time. And he's quite correct. Budgetary authority is the big piece of the pie. I'm not afraid to be the guy who makes that call, however. I think that's why they pay us, is to make those decisions, make the tough decisions. I do believe, and I understand, I agree with Captain Price and General Baker in their points that we can go to the judge to get resources, expert assistance, investigators. But my concern there has always been that in order for us to do that, we first have to go to the prosecutor. And we have to lay out our case to the prosecutor and say, here's why we think we need this witness. Here's why we think he is relevant, necessary, and material to the defense. And then the prosecutor is going to say no. Of course he's going to say no. So then we have to go to the judge. And then we have to lay out our whole case to the judge as to why that witness is relevant, necessary, and material to our defense. It could be a fact witness or it could be an expert witness. It doesn't matter. But we have to present our case to the judge in front of the prosecution. There's no ex parte hearing. So for me, that's problematic. And that's where I come to the point of my concern about evidence development, is because we have no subpoena power. We don't have the authority to get evidence. We don't have the authority to get witnesses. If I want documentary evidence, if I want a witness, I have to go to the prosecutor and ask the prosecutor to get it for me. So to some degree, having that budgetary authority would help us in that regard. Now, that's I think in a fictional world where there are no limited resources. So long as we continue to live in a resource-constrained environment, we've got to find another mechanism to solve that problem. I think one of the things that the Military Justice Review Group brought to the fore was the idea of a magistrates program. And I hope that we can utilize that magistrates program to help us as defense counsel hold ex parte hearings to help develop that type of evidence that we need to defend our clients without having to lay our case out.
I think just briefly, I just emphasize something General Baker said earlier. Institutionally, the man, train, equip component of the mission is true for all. I think it's essentially the same in each of the services. Whatever structure we belong to is responsible for that. The cases themselves, the funding of the cases themselves in a command-centric system, as we've discussed, involves the convening authority and ultimately the military judge. So I think that bifurcation is critical to this follow-on answer. To answer your question directly, I like the model where we have independent commands apexing at an individual. Obviously, that's dependent upon a competent, fair, professional individual occupying that position, and that's a significant responsibility. I like it though. We have equal pay. We have similar promotion schemes where folks are advanced. I'm unaware of any statistical anomalies or differences. We have a lot of back and forth. Now, this is where we may be very different, and I learned this in the MJERG from that in the Article 3, the practices in the states and in the federal district courts, is I think most of us probably believe, as General Baker articulated earlier, that you're a better defense counsel having been a prosecutor, you're a better judge having been both, and we haven't even talked about the staff judge advocate, who's the in-house counsel. My personal view is it's difficult to be a competent staff judge advocate and advise a commander on military justice. It's most important you've been a defense counsel previously to understand that side of the equation. So I suspect that, and that'd be an interesting question, that the majority of us probably believe there's tremendous value in that cross-pollination. And to maybe go at your last question, that's not uncommon to the military model. In that regard, we're not that different from most other communities. So that wouldn't be as shocking to military members that they may see you in different places as it may be on the outside. But to answer your question directly, if I could improve that model, and concurring with Colonel Newman, I would advocate for some level of independence within the defense bar for investigation, for access to experts, where you didn't have to actually make a showing either to the convening authority or the judge. Obviously, that's ripe for problems and challenges. I think we're moving that way in the Navy, and partially because the RSP looked at it from the outside, but I do believe that's an area where we can improve the quality of our defense services. Obviously, managing that would be a greater challenge,
Thanks.
All right. Judge Goldberg.
Do you gentlemen ever get tired of people saying to you, "Thank you for your service"? Thank you for your service.
Thank you for your support.
I have some experience in the civilian criminal justice system, but no experience in what you folks do. What I know about military prosecution, you could fit into a thimble. So I have some really basic questions. And I thought I was following everything until Colonel Newman talked about going to the prosecution for resources. So I need to get that straight in my head for a second. So why don't we take a really simple, if we can, hypothetical sexual assault case. The prosecution needs a DNA expert. So first, really basic question. Does the prosecution have to go to the convening authority to get money to hire a DNA expert?
In theory, yes. In practice, no.
Could you explain that?
The
Explain that.
rules say that, Rule for Courts Martial 703 says the parties go to the convening authority to approve funding. Having been having sat in all the roles in the process, the prosecution is going to get a DNA expert in a sexual assault case.
Who signs the
So here's what's even crazy.
paperwork that
So
authorizes
it
the money?
It depends who the DNA expert works for. The DNA expert is a government employee. Normally the investigators, the Navy and Marine Corps, NCIS, is going to send that piece of evidence off to get
Let's say it's an
tested.
outside
Okay, so
expert.
if it's an outside expert, then then the prosecution would go to the convening authority.
Okay.
And then what's even crazier is the convening authority would approve it, and then a different person actually has to write the contract because the convening authority doesn't have contract writing approval. But for a lot of our experts, we have an in-house. DNA is a great example. There's a lot of government DNA experts. The investigators are going to already have that done. When the case comes to the defense, they're going to want their own.
Right.
Well, they have to go to the convening authority to get approval for their expert.
And let's just say, sort of tweaking the hypothetical out of reality a little bit,
Yeah.
but let's say, before that, next question is, so, and I think you just said it, once the prosecution is brought, the defense says, I needed a DNA expert, and the defense attorney then has to go to the convening authority as well to get their own expert, right?
Right.
Okay, so where's the part I missed is, I thought there was, Colonel Newman said something about, before that step, the defense has to go to the prosecution?
Yes, that request is routed through the routed through the trial counsel. Now in the commission system, we've essentially done away. We have a lot of ex parte requests. So
Right.
I'll let these guys talk about the.
What General Baker says is correct. The way that request would work is I, as a defense counsel, would have to lay out in writing why I think I need that expert. And I would have to submit that to the convening authority through the prosecutor, the individual that we refer to as the trial counsel. That trial counsel will then chop on that and make a recommendation to the convening authority. It'll also go through the convening authority staff judge advocate who will make a recommendation as to whether or not it should or should not be approved.
And those disputes are ultimately decided if the convening authority says no for whatever reason, just follow my
That's
very basic
correct.
hypothetical. The judge then decides whether to allocate the resources or not.
Post-referral. Yes, sir.
Yes, okay.
Prior to referral, we just have to bide our time.
Referral to us is the formal charging and referral to a court martial.
Understood. Okay. So what is your collective experience as to whether, and understanding the inherent problems of the defense having to lay out what they want to do, but in my hypothetical understanding, it's really simple. The prosecution is going to know that the defense is going to have to hire a DNA expert. So no great revelation there. In your collective experience, are the judges in your system supportive of defense requests? And since the prosecution has to ask as well, maybe you could talk about that as well. Or do they meddle, for lack of a better word, and do things like, well, maybe that expert's not necessary, or let's save some money, or we have, this is taxpayer money, or are the judges more deferential to your mission?
It largely depends on the judge. That's the first answer. Secondly, the first thing the judge is going to do is going to ask, we are going to have, there's case law out there that talks about us having the ability to have an expert that meets with our theory of the case. But the first thing the judge is going to do is ask, why this guy and not a reasonable government substitute? And a lot of times, that's the compromise that is reached, is they give us a reasonable government substitute, not the person that we want, not the person who fits within our theory of the case, be it DNA or whatever. We get a reasonable government substitute from the Navy Hospital, or from USACIL, the Army Criminal Investigation Lab, or from AFib, the Armed Forces Institute of Pathology. We get what the government believes is a reasonable substitute, and we work with that.
Do you have any recourse if the expertise of the expert approved for the prosecution is so superior to the defense expert?
Oh, yes, there's recourse. There's an Article 60. You can do a writ to the appellate courts, but that's going to be denied.
And you can, I mean, the other recourse is to litigate the issue and continue to bring it back to the judge. And that's part of the problem, that's part of a flaw in our system, is the delay it takes kind of from defense counsel concept of I need X. And this is really exacerbated in the commission system, where the defense counsel decides that they need a particular expert. If the convening authority doesn't approve that, then it's got to go to the judge, and that can take months. And until somebody authorizes you to do that, you can't get that expertise. On the flip side, the prosecution has they have an extensive law. They've got all the law enforcement assets to include reach back to experts that we just don't have.
I would take a little different view, only I don't think conceptually, and I think it's important to understand there's a statutory basis, I believe Article 46, okay, 46 to provide equal access. In my experience, it's not so much access to the expertise, and our judges, like any judge, wants to ensure they have a sound record when they go forth on appeal. And there are a number of cases that have been reversed because of an inadequacy or inequity with respect to the expertise provided, particularly when a good record is made as to the importance of an individual expert. I would agree with Colonel Newman absolutely. The majority of the litigation, and the greater challenge to the defense bar, is obtaining perhaps their expert, my term, not a legal term, expert of choice, let's just say, as opposed to, and I'm drawing a blank on the actual language, it's not reasonable substitute. Does anybody remember there's a term that's escaping me at this point, but someone who's essentially an adequate substitute for that individual, I believe may be the case law phraseology. But this is actually very heavily litigated, and I'll use by way of example, trial just recently in my in a courtroom, my counsel, they had 5 experts in a sexual assault case that were in the trial for 2 weeks, all provided by the government. Again, all of that was a product of very aggressive, very zealous pretrial litigation. And the judges essentially ordered their production. Not all of them, actually. The convening authority, I think, ordered the production of 2 or 3, and then the judge essentially concluded. So it does vary by judge, no question, and it does vary over time. But I think particularly as we get more into complicated cases, there's a clear awareness, and I'll use my experience by way of example. That law existed on the books when I was a trial defense counsel in 1989. But it was nowhere near as well understood or exercised. This is all post-Ake, but nowhere near as well understood or exercised that it is now by our counsel. And I think that's actually true across the services. Our defense counsel assistance programs are really zealous on pushing the access to expertise. And candidly, there are a number of folks out there that we know about that we talk to pretty frequently. That said, as a formal matter, to get the person paid and produced at trial, you have to do exactly as described, submit the request. But, I would add one other thing. One of the MJERG proposals was actually, as addressed here, to one, provide judges pretrial opportunity to rule on things like experts, and secondly, to look at things like issuance of subpoenas, potentially even, and I don't believe this made it in the final legislation, so I wouldn't want to be quoted, but some consideration with respect to ex parte communications from the defense bar. Those were examples of where we learned that our system could be improved by looking at the Article 3 rule. So.
And just to clarify my comment, the judges typically are very receptive to our requests. We have good judges. My concern is that I, as a defense counsel, have to lay out my case in an open forum and describe for the judge why it is that I need that.
And it's experts aren't the problem.
Excuse me?
Experts really isn't the problem. Ask Colonel Newman how he gets a fact witness.
How do you get a fact witness?
I have to go to the prosecutor. I asked the prosecutor for I need Lance Corporal Beltbuckle to come in from California. We're in Camp Lejeune, North Carolina. I need Lance Corporal Beltbuckle to come in to testify, to impeach. And he's going to say, it's too expensive.
So
No.
you know what you folks are doing? You're making the defense attorneys on our panel nervous that we're going to propose something like
I like that.
the defense bar has to go to the prosecution. I just have one, just really quick question, one more quick question. Did one of you say that when charges are brought, automatically it doesn't matter what your financial situation is, you get counsel?
Yes.
And when a civilian counsel comes in, what happens to the military counsel?
The military counsel becomes what's called an associate defense counsel. The military counsel stays on the case. Now, who within that defense team serves as lead counsel is an issue between the client and the defense team, but the military counsel stays on the case unless released. We also have besides your right to civilian counsel or detailed defense counsel, in my case, I have some civilian employees and some military employees. You also have the right to request an individual counsel that you want. So if another military counsel, you could ask for them to come defend you, and if they're available, they will.
And typically, when that IMC request is approved, the standard is that the detailed counsel is relieved unless there's a reason to keep him or her on.
And ultimately, that decision in the Air Force falls on me, and whether I keep that original detailed counsel on when the individual military defense counsel is appointed.
When we make those decisions, we have to be very careful because we don't want to give the appearance that we're using that authority as a sword to run up costs. So it's a very delicate decision sometimes as to whether or not the IMC is approved or not.
All right. Judge Walton?
General, I feel your pain in reference to the Guantanamo Bay detainee cases because as a district judge in Washington, I was assigned the largest number of habeas detainee cases, and I issued what I thought was a well-reasoned opinion setting forth what I thought were the basic due process rights they were entitled to. And the Court of Appeals rejected every one of those positions. But one of the things that you've expressed, which is a concern that we have in the civilian world also, is the lack of resources for defense counsel. And what impact do you think what you've indicated regarding the lack of resources has on your ability to provide quality representation to your clients?
It absolutely has an adverse impact. I'll just confine this to my current job. I sat down and I made a resource decision based on what I what I think are the basic requirements to provide an ethical and zealous defense for our clients. I made what I believed was a conservative view based upon 25 years of doing this, and the convening authority gets to make a decision whether my assessment was right or not. In my view, if he doesn't prove what we've asked for, it's going to absolutely adversely impact our clients. it's hard to describe the scope of the work, particularly in discovery and other areas in our cases. I don't have enough people to do that job. One of the when I took over my job, I told my folks, in the military we always told you can do more with less, and you suck it up and you move on. They need to stop sucking it up and start asking for things. We want the process to be fair, and we need the resources. Right now, I don't think we have the resources to make that the system is fair.
I mean, at bottom, I think our major concern, and I'm sure it's a major concern of yours, is whether we are wrongfully having people convicted because of lack of resources. Have there been any documented cases where it's been shown that individuals have been wrongfully convicted, and you can attribute that directly to lack of resources?
I can't say that there's been so few people convicted in the commission system that I'll let one of my colleagues answer that question.
What about in the non-commissioned system?
I can't think of any off the top of my head. I know that there were a series of cases where one of the DNA experts from one of the Army Criminal Investigation Labs had been, for lack of better words, inflating his figures. And so all those cases got review. All those accused were notified by the Assistant Judge Advocate General of the Navy for military justice. And so I can't think of any particular cases, but I will say, and I've been quoted on this before, no one here thinks we've got a perfect system. So unless you can guarantee me we have an absolutely perfect system, somebody out there has been wrongfully convicted of something in the military. We just don't know it. I guarantee you we don't have a perfect system. I've been doing it for too long to know better. But in direct answer to your first question, General Baker, how does it impact our function as defense counsel? Well, defense counsel end up having to work as investigators. They have to go out and do those things that investigators would typically do. Defense counsel have to have, when they're conducting witness interviews, they need to have what we refer to as a prover in the room. So they bring in another lawyer who sits in the room with them. And then when that witness goes south on the stand, you bring the prover up to take the stand to impeach. It adds a lot to their workload. Now, that being said, my defense counsel are doing exceedingly well. They're performing well above standard, and they're getting exceptionally good results. But they're getting exceptionally good results under what I consider to be difficult circumstances.
I don't know if you can quantify this, but how many individuals are your lawyers representing at any given time?
Geez, I had that figure last week. I can get back to you on an exact number on that if that's okay. I don't want to guess.
There's no limitation on how many cases they can have at any given time.
Well, I will say that we try to limit. We try to keep their caseload commensurate with their ability to handle cases. In our day, when we were line defense counsel, line trial counsel, we were carrying 25, 30, 40 cases. Could have been, a lot of them were small-time cases, though. We don't prosecute the same type of cases today that we did 10, 20 years ago. As General Baker has said on a number of occasions, our litigation in the military, our numbers may be going down, but the nature of the litigation is getting increasingly complex. So I think that's mirrored in the civilian sector as well. Because the litigation is becoming so complex, the defense counsel are finding themselves challenged to play both the representative role and do the things that a paralegal or an investigator might do.
Is that complexity the result of any particular thing, the nature of the case, or the nature of documents that are now being produced?
I think it's a function of the wars, quite frankly. I think after September 11th, there was a switch that was flipped. Commanders decided that they would rather dispose of low-level misconduct as quickly as possible so they can get their units to the fight. So the cases that we used to prosecute, the single spec, what we call single spec 112 alpha, single spec drug case, wrongful use case for marijuana or something like that, something that we would have prosecuted back in 1995. Today, you're going to find that guy go into administrative separation board. He'll go to non-judicial punishment and be separated rather than going to prosecution. A single spec unauthorized absence, where a kid, doesn't come back from leave or something like that. Those are cases that are going to be handled administratively, whereas, in 94, 95, we might have prosecuted that case. So the nature of the cases are now sexual assault, complex litigation type cases.
As my colleague said, thank you for your service.
Thank you, sir.
Mr. Khan,
Gentlemen, first, thank you for
microphone.
First, thank you for these cords are so short. Thank you for the extensive written comments. They were very helpful. At the end of reading them, I thought I understood things. I now know I understand nothing about your system. So I'll ask some questions which will probably only increase my ignorance. But let me begin. You mentioned that when you have to go to the judge to ask for resources, that can't be done ex parte. You've got to disclose your entire case to the prosecutor. Is that the same when you go to the convening authority for those resources?
I can speak for the Air Force. We have to lay out to ultimately the prosecutor that it's routed through exactly why we think we need that expert and what they're going to provide that we cannot do on our own. So I guess the answer is yes, that they will see. Ultimately, if I am going to the judge, it may be even more extensive when I'm putting in front of the judge in order to justify this expert, but they will know what it is I'm looking for that expert when I make that initial request.
That's exactly right. And, when General Baker had my job, I was a staff judge advocate at the 2nd Marine Aircraft Wing. And one of my common indictments of his defense counsel at the time was that they were too coy as they were making submissions requesting expert assistance because I couldn't tell why they needed it. And he would complain to me, well, we're not going to lay out our cases for you. So you can see how that's been playing out for years. The submission has to include why you need it, and it has to be pretty specific. Otherwise, the convening authority doesn't have the ability to approve it. He's got to have a reason to approve it.
What discovery obligations are there on the prosecutors with regard to their case?
We have broad-based discovery. One of the material changes in our system we're all still adjusting to was a change to our preliminary hearing model. We used to have Article 32, it remains the same codal provision, but it used to be a full-blown, or could be a full-blown hearing with cross-examination of complaining witnesses, some lessening of the rules of evidence, but very, very comprehensive. A few years back, Congress changed that for any number of reasons. I think we're still adjusting is probably a fair statement, but even at this point, the President, when implementing the rules, requires the prosecution, even prior to that hearing, to turn over any documents that were forwarded that resulted in the charges. And then prior to trial, our discovery rights are about, and this I'll flash back to my engineering experience, we did not find a system that had more favorable rules with respect to discovery. The issue was timing. No real discovery right attaches until charges are referred, which can be very late in the process, obviously. The 32 piece used to be an opportunity to discover a lot about the government's case. But very liberal, I guess, is the best way to phrase it. I will say this, and we just had a meeting recently where we learned that each of our services have employed highly qualified experts. And our sense is that on the prosecution side, some of these folks are bringing practices perhaps from the civilian world that are less disclosing, if that's a fair statement. And we've been, each of the services have been wrestling with that in different ways. The rules themselves are very favorable, and the judges, candidly, having been a judge, and Judge Baker I'm sure would say this, if you saw the government messing around with their discovery obligations, that would cost the government time. You would not hold that against the accused. So our system is set up to be efficient, and one of those efficiencies is the discovery piece, whether everyone complies in every case as well as they should. But the rules themselves are, I think, very favorable.
And
I'll
those
just
rules
say
are
that-
uniform across the services?
Yeah, the Uniform Code of Military Justice applies to all the services,
Okay, so-
including the Coast Guard, and the rules for courts martial are issued by executive order, and they apply to all the services. Now, having said that, again, MJERG experience, it was stunning to me how fundamental things that appear to be the same are done very differently in each of the services. And I think so it's difficult for each of us to speak with absolute certainty about what the other services do, but the rules themselves are absolutely uniform. There are lower level regulations the services may implement that may expand upon those rights that may vary by service.
So one of the questions that we're very interested in that we've been looking at is the ways in which burdens on obtaining resources dissuades people from making the requests in the first place. And you've got a more burdensome system in place than we have. For, our CJA lawyers go to the judge, they go ex parte, they make the case for the expert or the resources they need, but they don't have to lay anything out to the prosecutor. Of course, nor does the prosecutor lay much out for us. But so I'm wondering what your experience is in supervising lower level defense counsel. How do you find that they adapt to your system? Do you think when you're reviewing their cases that they're making optimal use of expert resources in their cases, of investigative resources, of any resources they need?
I believe they are, but under the constraints of the system in which we operate. As Captain Price mentioned, we have highly qualified experts. We've hired 2 in the DSO. These are both 30-year veterans of the San Diego County Public Defender's Office. We have one at Camp Lejeune and one at Camp Pendleton, one on the East Coast, one on the West Coast. And what counsel are doing is relying on those 2 parties to provide them with a sight picture on what experts they need and why. So that's been very helpful. One of our critical shortfalls I can't speak for the other services, but I think it's probably the same, is the inexperience of our counsel. They come in typically straight out of law school. In the Marine Corps, they go through the 6-month basic school and then hit in Naval Justice School. The Navy's a little different. But they have very little experience litigating. And so in order to address that kind of critical shortfall in experience, we hired these HQEs, as we call them. And they've been very, very helpful to us in helping develop motions and skill sets, training and whatnot for our young counsel. So to the extent that the system will allow, my counsel are utilizing expert witness and expert assistance to the extent that they can. But as I've said, they try to be as coy about it as they possibly can until they're required to meet their burden.
Let me ask you, Captain Price, you've got kind of a control group experiment going on because you now have this new investigative unit or corps or whatever. I don't remember the acronym you used for it, but are you finding that now that you have that there's been any change in the way in which your trial counsel are investigating their cases?
I wish I could speak with knowledge. My 2 have not reported yet. One reports in later this month. I have one DLSS reporting to my office in Washington and one reporting in Naples, Italy. I can speak generally. It's still a nascent program. I mean, we're talking 6 months or so since the first folks have been aboard. But I think like anything else, when you bring in expertise, we recognize now we had some blind spots we maybe didn't understand before. I agree with Colonel Newman. Our counsel do as best they can. We have differing degrees of paralegal support in the service as well, so I won't speak to that. But with respect to the Navy model, we're actually certifying paralegals, and we've discovered that our paralegals often bring investigative skills that our attorneys don't have. And that's not a historical model. I can tell you 15 years ago that was not true in the Navy JAG Corps. So that's, I guess to answer your question, I don't really know, but I think we will get better. So I guess that means we haven't been doing it as well as we could have, if that's an answer.
Yeah, no, that's helpful.
I have investigators
And-
in the commission system. Do they have the exact skill set that we want? No, that's a conversation for another day. But absolutely, my council approach cases, I see my council in the commission system approach cases with much better expertise with an investigative plan than the services have. And they don't have the investigative resources that I do. Having been involved in a system that has it, if I ever go back, that's going to be one thing I'm going to advocate for.
So you actually brought up an interesting point, which is a thread that I saw running through at least your testimony, your written testimony, that of Colonel Tanev and Colonel Newman, which is about the evolution of your systems and the advocacy for change coming from within the system. And it seemed to me, if I read your testimony correctly, the dissatisfaction with the systems following the Vietnam era led to changes that took place at various times in your systems. And I'm wondering if I could get each of you to talk a little bit about how, where that change come from. Was there a top, recognition at the top tiers that filtered down? Was it dissatisfaction that came from the bottom that moved the services? How did those changes come about to a more independent defense function?
Can I attempt that one just
Sure.
First of all, probably the biggest change in the code when it first became uniform was post-World War II. Change before that, of course, was post-World War I, but the Uniform Code was absolutely the biggest change. Went into effect in 1951. The defense bar reporting to lawyers was essentially the Secretary of Defense in '73 directed all the services to look at creating a bar that reports to other lawyers. Prior to that, in the Navy, by way of example, many of our defense practice was actually done by non-lawyers. Very, very different model. But I think the '73 SecDef memo that directed this more independent defense function, and again, we each did it differently, but in that regard, it was uniform. What we did after that, I think, varies. Is that a fair statement?
Yeah. So I gave a talk on this for one of Colonel Newman's CLEs. Where change comes from are from the litigants or from the people involved in the process. Is it the people at the bottom? Yes. Is it their managers? Yes. Is it the people at the top? Yes. You have to create the record to make the change. That's why on this panel, this is such an impressive expenditure of resources, time, effort, and energy by the Office of Courts, and this is just incredibly impressive. We affected, Colonel Newman and I affected change in the Marine Corps through persistence and standing on the back of 40 years of work of our predecessors. But change comes from those involved in the process.
I would agree with the Air Force. They looked at the model at all levels and saw an area where they thought they could improve it, and ultimately it was the two-star general who made that decision, but it was the people on the ground feeding up information that ultimately led that two-star to come to that conclusion.
Change is hard. And it's hard because it's not just because it costs money, but because of institutional muscle movement, and institutional memory. People like the things the way they are. But change is good. In our particular case, as General Baker said, we had 40 years of a record upon which to rely. And I think if you talk to my boss, Major General Ewers, he would tell you that one thing I'm good at is writing strongly worded letters. And so we've been writing strongly worded letters for 40 years, men and women like me. But unfortunately, it's only when there's a crisis, be it small or large, that those strongly worded letters become important. So it's important to write them, but I think it's more important to read them and consider them before the crisis hits. Because then you're not reacting. You're not in a reactive mode, you're in a proactive mode. Over the past 3 or 4 legislative cycles. There have been some 60-odd changes to the Uniform Code of Military Justice. And it's largely because we're in reaction mode to things that we weren't doing well before. So that's kind of a long answer to your question, but my response is don't wait for the crisis to occur when you have the opportunity to change now.
Let me ask you, loop into that with something else that you spoke about in your written testimony, and that was the dangers of making small piecemeal changes. And can you talk a little bit about what you meant and about what problems you've seen arise from that?
Well, yes, sir. What I was trying to get at is there's a tendency to try and execute change within existing authority rather than do the hard thing, which is to change the authority. Whether that be statutory, a legislative proposal, or rewriting the regulation. There's a tendency to try and execute that change in small measures, in small doses. And we did that for 40 years. I think that those small changes are what led to the requirement, some may say it wasn't a requirement, I think it was, the requirement in the Marine Corps to reorganize their legal services, as we did in 2012. It's 2012, right? That over years of small kind of left and right tack changes, we ended up with structure that didn't match our manpower. So we had people in billets that didn't exist, people in jobs that didn't exist on paper. And so as a community, we looked over strength, but when you actually looked at the jobs we were doing, we were under strength. So it created a mismatch in resource allocation. And General Baker can speak much more eloquently to that, having been involved in that process more than I was. So that, in the end, I think led largely to the problems that we had in United States versus Lee.
That's the case that you referenced in your written materials.
Yes, sir.
The imbalance in resources.
Yes, sir. And, in full disclosure, I was deeply involved in that case because I was the Regional Defense Counsel at the time. And it was a matter of, they needed lawyers to go to the fight. And so they were taking lawyers from the LSSS to go support the operating forces. And we were, but what they weren't taking with them was the military justice. The cases were staying back. So we still had to represent Marines, and they were still prosecuting Marines. And so we were diminishing resources, increasing demand. And so we made the best decisions that we could under those circumstances. But the problem was that we weren't properly structured. So I'm not sure if I answered your question.
Yeah, no, that's helpful. I'd ask if any of the others of you, General Baker or Colonel Tanner, Captain Price, have any thoughts on those sort of system change issues, because you've gone through a period of significant change over the last 40 years, and we're looking at whether or not we should engage in that process right now.
Colonel, I think Captain Price Captain Price just spent a year and a half looking at our system and proposing article by article with a group of people proposing change. So it wasn't piecemeal, and it wasn't. It was a slow, deliberative process. I know they wanted more time to it. So I guess I'll let Captain Price answer that.
I'm not sure I can. I guess I'll step back to my organization first for the Navy. Clearly changed movement from all levels, but I think in the Navy JAG Corps, and I speak candidly when I say this, we've had some visionary leadership for a number of years that have focused, and the Navy's put a big focus on strategic thinking, and our leadership has bought into that. And so our changes, and as I noted in my comments here earlier, we haven't really changed that much. We've the commander remains the commander over the commands that provide the support to prosecution and defense. The other aspects of their responsibilities have shifted back and forth. But the structure has largely remained intact. And I think that the vision, and I'm not trying to sound, this is my personal view, I think their vision was to align our organization with the Navy as an organization to best posture us to accomplish our mission. I'm actually generally satisfied with the solution. And it was involved in a couple of the steps, and candidly, at each of the phases was not particularly supportive as these changes were underway. But we had the advantage of an organization that was shifting as well. I think what's important to remember in the military, and we sometimes forget this, go to the MJERG example, our military justice system is intended to function and not just survive, but function and perform well, both in a time of relative peace and security and in a time of absolute world war with a complete conscript organization. So it's sort of this amazing model that is to expand and contract as the demands may require. But I think that visionary leadership is critical. I think someone, and using my community as an example, the ability to look and see what the challenges would be in the future. And again, I can't speak knowledgeably. I'm aware of the lineup and the alignment within within the Judicial Conference and the Administrative Office of the Courts and the like, but I can't speak knowledgeably. But I think one interesting thing to me is, and I don't know who the senior advocate is for the public defender model that exists, but I think it's important to have a person who literally is responsible for the mission, and whatever that mission is subordinated to, understand how it fits together with the other mission to best figure out how to align it. I know that's not an answer.
No, actually, that is an answer. That's a helpful answer.
Well, as an aside, and when I was looking at our model, one thing that jumped out at me was this chief of staff function within our organization, where I talked about the Commander, Naval Legal Service Command in our model, 3 chiefs of staff who essentially perform the functional management day in and day out. And they take the temperature of the organization, and we're relatively small. I mean, the Navy Defense Bar of real litigators is only about 51 lawyers. We have 90 folks, but 30 of those, a third of them, are new judge advocates who are handling the low-level administrative stuff. So our real core bar is about 50 plus leadership, about 60 total. It's not that large of an institution, but we feed constantly, and we're constantly reassessing. To go to the MJERG piece that General Baker mentioned, I think one challenge with that model was we were giving a reference point, that being the federal civilian system, to look at where we were different. If we were different and it made sense to stay that way, do so. But if it didn't, at least think about it and look at best practices. That was really eye-opening to have a model to look at. So my sense, and I know from talking to Aaron, is hopefully we provided you with some comparative models. And I hope you recognize, I know we don't necessarily recognize the distinctions between each of our little models that operate under the same uniform code, but we have structural differences. But I suspect that our organizational leadership would feel that our models suit or meet the mission requirements of their respective organization, although each of them can be improved. I don't know if that's a fair statement.
Could I ask a process question? I understand your concern about saying that there are risks at seeking incremental change. And if you philosophically believe that systemic change is needed, but you have questions about whether that systemic change is achievable, are you saying that it's better not to even seek the intermediary changes, or what do you do?
I do not believe that you do nothing. Doing nothing is never an option. I believe that, you take the change that you can get. And this is another conversation that I've had with General Baker over the years, is that, take the change that you can get and project forward. Take what you can get and roll with it and develop it and build it. But keep building the record. Those are his words, not mine. Build the record, build the record, build the record. People have to write. They have to write articles. They have to write memos. They have to speak before panels and build the record.
So do you articulate ultimately what you believe is necessary, but as
Captain
an alternative?
Yes, sir. Captain Price is 100% right. There has to be somebody who has the vision for where you want to take this organization. And at some point in time, somebody just has to make a decision.
Related, I don't know if it's related with that, but this is what's running through my head is, I really challenge you all as you do this to examine your existing practices and kind of the way we've always done things. So when Colonel Newman and I and Christian Capecci is in the back, he's going to testify next, grew up in the Marine Corps, it was not uncommon that you would prosecute a case and you'd spend your time, you'd finish your time as a prosecutor, or it's usually the reverse, you'd finish your time as a defense counsel, you'd go over to be a prosecutor, and you'd finish up your defense cases. And nobody thought anything about that. And we had a whole bunch of very smart, motivated, intelligent leaders like us, and nobody thought anything about that. And then now that we look back, and I can't believe that there's certain practices that we did. So I really challenge you to, and this is an opportunity to make substantial change if it's needed. But I really, this is a wonderful opportunity to examine your system, set that strategic goal, and then try to achieve it.
So I have a question, because I think when we started, I think it was General Baker, but I'm not positive. One of you said, I can't believe you're thanking us because, or you're wanting to hear from us because we look to the system that you have. So I want to ask each of you what it is about our system, what it is that you look to, what you see from the outside looking at us that you would like to emulate, or that you think is a symbol of the way things are done right, or that you wish you could incorporate. And I'll start with you, General Baker.
Then I'll do this from a commission's perspective. In 2009, the Military Commissions Act was passed, and buried within the Military Commissions Act was a sense of Congress that talked about the way the commission's defense should be resourced. And they suggested that we should be resourced along the federal model. So what do we see that when I look out at the federal system, and that I probably don't really know as much about as I think that I do? One is a group of incredibly experienced criminal defense attorneys that have a lot of training and that seem to have access to resources where you don't have to go to the prosecution to get them. I've read a whole bunch of stuff that was on your website, submissions from federal defenders and others that talk about the challenge of, absolutely, there's a challenge that I didn't know existed. There's got to be a way to provide a defense organization adequate resources and trust the supervisors of those defense organizations to provide those resources. No system yet has that. I feel like you guys are closer, but I didn't realize. But you've got the judges that are making that decision, and not the federal defenders. I guess so. One word is professionalism. We look at the federal model as just having a wonderful group of professionals.
Colonel Tan.
I would say, much like the Navy has started with having their own defense investigators, that is something that we've looked at the federal system, and I think it's definitely an area of need in our system. We are, relying on our lawyers and our paralegals to do all of the investigations for the cases. Only in the most serious of cases are we getting any kind of investigator appointed by a judge or anyone, or a convening authority for that matter. So that is one area where we're looking to improve and follow on to your system and how you guys do it.
Colonel.
I agree 100% with what General Baker said, is the level of professionalism and experience that you find in the Federal Public Defender's Office. I think you opened up this portion of the hearing by suggesting that we don't really have a dog in the fight because we're military guys, but That's only true for me until May 13th. Because as of May 13th.
Can we sign you up?
As of
He's
May
been signed
13th, I will be the federal public defender for the Northern District of Ohio.
Oh.
So, thank you. So
Wait till he finds out what he got himself.
well, I have a taste. So I do have an interest in this. I'm excited about the opportunity. When I got the job, one of my first comments was, finally, I got my investigators. But I
Just
had to
wait.
leave the Marine Corps to do it. So it's the level of professionalism, it's the access to resources. I understand there are challenges in the allocation of resources, but I would say that one advantage that I have as the CDC is the ability to assign cases, and that authority vests in me. As I said in my opening remarks, that is the most important responsibility that I have, and it's the most powerful tool that I have, is making sure that that the right counsel is assigned to the right case. There needs to be one party who's responsible for that.
Thank you. And Captain Price.
I would say this will sound somewhat uniform for a change. The access to investigators and the consultants, the experts, those are two things that I think we look at as the gold standard. And I don't understand all the limitations that may exist, but at least by model, and those appear to be significant benefits to both, in my view, the defense bar and the interest of justice in the long term. I understand there'll be constraint issues with respect to the resources, but we could do better.
All right, thank you. Any questions back here? Anybody? Gentlemen, thank you so much. Thank you for your service, first of all, but no, thank you so much for being here today. We so much appreciate it, and it's been very enlightening because we really are trying to figure out what's the right thing to do, and hearing from you, and honestly, it's been very inspirational in a lot of ways. Hearing from you has helped, so thank you so much. And I know some of you indicated you might have some things you want to add to your submissions. Feel free, once you get back to your office, or if you think of something that you'd like to let us know about, feel free to give us any information, because we really are appreciative of that. So thank you very much.
Thank you.